Welcome to YouTube classes. We are going to start your YouTube session on Indian polity for civil service examination, an initiative of Vanik, the mega institution. Last class we have discussed the interstate relations, and in this regard we have discussed executive relationship, administrative relations, and your legislative relations between the center and state. And we have seen that many type of a very a typical arrangement is provided with regards to administrative relations and also the legislative relation. Apart from that, there are other provisions in which the center and state also interact, like cooperation between the center and states, interstate council, and zonal council also can be a mode of things. So, and also disputes over river water is the responsibility of the center, and there are public service commission, there are integrated judiciary. Apart from the constitutional statutory provisions, there are some extra constitutional arrangement for contributing towards center-state relations, like governors' conferences, chief ministers' conference, chief secretaries' conference, conference of inspector general of police, chief justice of conferences, and the conferences of vice chancellors, home ministers' conferences, so on, the law ministers' conferences, and also the conferences of presiding officers. So various methods are undertaken to strengthen and make the center-state relations and make it durable and cordial. With regards to financial relations, we shall discuss it broadly. With regards to financial relations, just a minute. So financial relations between the center and states. Finance is the fuel of administration. It is most important aspect of governance. Unless there is a sound financial relationship between the center and states, it will be other relationship may lose their importance, may lose their significance. The legislative relations, the administrative relations are also successful if there is a financial relationship, sound financial relationship exists between the center and states. Another thing, the devolution of financial resources is somewhat tilting towards the center, and the center has more financial autonomy and financial powers than the center. So in this regard, the financial relations between the center and states holds importance. Article 268 to 293 in part XI, in part XII of the Constitution deals with center-state financial relations. Center-state financial ଅର୍ଥନୈତିକ ସମ୍ପର୍କ जोटा कहते ଆମର, so it is center state relations deals in financial 268 to 93. The parliament as exclusive, the parliament has exclusive power to levy taxes on subjects enumerated in the union list, isn't it? So any subject mentioned in the union list, the taxable subjects, which are 13 in number. The union has power to impose taxes on 13 important subjects mentioned in the union list. The state legislature I am meant to make it black. State legislature has exclusive power taxation subjects mentioned in state list. That is about 18 in number. And in this regard, Constitutional 101 Constitutional Amendment Act 2016 has made an exception by making a special provision with respect to goods and services tax. Goods and services. There has been a deviation in the GST. After GST was implemented, there were some changes in the center-state financial relationship. So it is an exception made by the making special provisions. Okay. So these are the major points you have to remember. The tax II deals with the financial relations between the central states. Parliament has exclusive powers on the subjects enumerated in the union list, that is 13 in number. We can summarize. And state legislature has exclusive power to levy taxes on subjects mentioned in the state list, that is 18 in number. But the 101st Amendment Act has made some exception in this regard, which refers to the imposition of GST, goods and services tax. Okay. The amendments, you remember GST amendment, has conferred concurrent power, similar power, both concurrent power upon the Parliament and state legislature So GST is made conferred concurrent powers, means similar power or powers to both upon the Parliament and state legislature to make laws governing goods. So both Parliament and state legislature, can make laws with regards to goods and services. It is a concurrent power. But the remaining power, the residuary power of taxations, and what is the residuary power? The power that is the power to impose taxes not enumerated in the that is your power that is not mentioned in the list is vested in the Parliament under Article 248. Under Article 248. The residuary powers. In fact, we have already got an idea that India is a quasi-federal state, and any residuary powers are vested in the center. That's why we are called a quasi-federal, because the states do not take the residuary powers; rather, the residuary powers are vested. So residuary powers means the powers that are not found mentioned in the three list, and there are certain important powers. So in this regard, the residuary power is vested in the center, and also the residuary power of taxation is vested in the center. So that is also a point to be remembered under Article 248. So in the post 8th Constitutional Amendment Act 2000 and 101 Constitutional Amendment Act 2016, so kindly take a note of this. After the 8th Constitutional Amendment Act, 80th Constitutional Amendment Act. So 80th Constitutional Amendment Act, 80th Constitutional Amendment, of the alternate tax sharing plan between the Union and state is covered by 80th Constitutional Amendment Act. 80th Constitutional Amendment Act. Okay. So the 80th Constitutional Amendment Act 2000, after the recommendation of 10th Finance Commission, this has been made. One of the recommendations of the Commission that has been under consideration of the government is an alternative scheme of sharing the proceeds of certain taxes and duties between the Union and states. The alternative scheme envisages the 26% out of the gross proceeds of Union tax and duties. Gross proceeds, gross collection, 26% of them, that will exclude stamp duty, excise duty on medicinal toilet preparation, central sale tax, consignment tax, cess levied for specific purposes under any law or surcharge, excluding all these things, is to be assigned to the states in lieu of their existing share in income tax, basic excise duties, special excise duties, grants in lieu of on railway passengers fee. In addition to 3% share in the gross proceeds of all central taxes and duties should be assigned to the states in the existing share of additional excise duties in lieu of sale tax on tobacco, cotton and sugar. The Commission had proposed that tobacco, cotton and sugar may continue to be exempt from sale tax, and the additional excise duty in lieu of sale tax on these items may be assigned with the basic excise duties. Where the alternative scheme would be more gainful to the center and the states vis-a-vis, existing arrangement would entirely depend on the relative growth in the collective collection of the various central taxes and the duties. The benefit of the scheme have been listed by the Commission in para of their reports. The benefits are that with the given share being allotted to the state in the aggregate revenue from central taxes, the states will be able to share the aggregate buoyancy of the central tax. The central government can pursue tax reforms without the need to consider whether the tax is shareable in the states or not. The impact of fluctuation of central tax revenues would be felt alike by the central and state governments. So that is alternative tax scheme. So 80th Amendment 2000 introduced alternative taxes, and okay. So there are many things, and also 101 Constitutional Amendment Act have changed the structure. So we shall see. Number one, what are the present system of financial relations, or what are the present system of financial distribution between the center and states? Number one, tax levied by the center So these taxes are levied by the center but collected and appropriated by the state under Article 268. Under Article 268. So what are the taxes that fall under this category? Taxes on the sale or purchase of goods. These taxes include taxes on the sale or purchase, on the sale Okay. So first category, we see that some taxes are levied by the center but collected and appropriated by the states. Under Article 268, these taxes include taxes on the sale or purchase of goods other than newspaper in the course of interstate trade and commerce. The entire tax will be collected appropriated by the states. Number two, taxes on the consignment of goods Okay, so taxes on consignment of goods. Taxes on consignment of good. Consignment of goods in the course of consignment means what? Consignment means delivery of goods in the course of interstate trade and commerce, and the tax is levied by the center but collected and appropriated by the states. So in detail, the net proceeds these two taxes do not form the part of the consolidated. That means they are directly appropriated by the states. They do not form the consolidated fund of India. That means they are centrally levied but collected and appropriated by the states. There are two variety of taxes that we have discussed. One is taxes levied by the center but collected and appropriated by the states. These tax includes on the sale or purchase of goods in the course of interstate, and on the consignment of the goods, that is delivery of goods in the course of interstate trade and commerce. Okay, so these are the taxes. They do not form the part of the consolidated fund of India. They are directly collected by the state. Then levy and collection by the so that is the thing about levied and collected, levy and collection of GST in course of interstate trade and commerce. Article 269A. Levy and collection of goods and services tax. The GST on supplies GST on supplies in the course of interstate trade and commerce are levied and collected by the center. Supplies, but this is tax is divided in the between the center and state in the manner provided by the Parliament on the recommendation of the GST Council of India. That is your 269A. Okay. So these are the levy and collection of goods and services tax in the course of interstate trade. This is all about your GST. Now, taxes Article 270. Here the tax is levied and collected by the center but distributed between the center and state. Article 270. This category includes all taxes and duties referred to the union list except the following. Including income tax, all the taxes number 1. Two 68, 269. Here it is very important because taxes, here the taxes are levied and collected by the center and distributed between the center and state. But this do not include the following duties and taxes referred to in Article 268, 269 and 269A that we have already discussed. In 269, the taxes are levied, collected. The taxes are levied, collected by the center but appropriated by the states that we have discussed, and taxes levied and collected by the center but assigned to the state 269, and taxes collected, goods and services taxes in the interstate trade and commerce can देखिए But here all the taxes are deferred, and that income tax and other taxes they are distributed on the recommendation of Finance Commission of India, but duties and taxes referred to because they are set aside in Article 269, 269A and also 268. And surcharges on taxes and duties referred to in the Article 271 do not form this part. So here the number 3 segment. Okay, now next is surcharge So these are exclusive earning of the center, surcharges on certain taxes and duties for the purpose of center, not taxes. That is wrongly written. Purpose of the center. The Parliament may at any time impose surcharges on the taxes mentioned in Article 260 and the Article 260, 269 and 270, and the surcharges found the exclusively belongs to the center. State has no share in the surcharges. So that is also a mechanism, that is also a procedure. The surcharges mentioned in the taxes which is mentioned in Article 269 and 270. Okay. The surcharge is an additional tax on a particular tax in certain circumstances. The center can impose certain surcharges on the items mentioned in the state Article 269 and 270 that we have discussed just. We have just discussed the things. So here the state has no share. It exclusively belongs to and states have no share in important taxation divisions between the center and states. So these are the taxes belonging to the state exclusively, enumerated in the state, that are 18 in number. These are the taxes belonging to the states exclusively. They are enumerated in the state list under 18 number. That includes tax revenue, taxes on agricultural income, duties with respect to succession of agricultural land, state duty in respect to agricultural land, taxes on lands and building, taxes on mineral rights, etc. Okay. So states have non-effective sources of finance, you can say. It's not viable source of income, and states are suffering from financial poverty. The distribution of non-tax revenue the taxes of non-tax revenue of the center. Non-tax revenue means that is not collected through tax, that is direct collected by the center. So the non-tax revenue are center of the center, like post and telegraph or communication, railways, banking, broadcasting, coinage and currency, okay, coinage and currency, central public sector enterprises, central public sector so you can find there are 6 major, and state and loss, another is there, state and loss. So you can see there are 8 major, eight major non-tax revenue, 7 major non-tax revenue in India. They are nothing but 7 major non-tax revenue in India. They are like post and telegraph or communication, railways, banking, broadcasting, coinage and currency, central PSUs, and estate and labs. Estate and refers to some abandoned property or some property which owners are not there. So that is we know as estate and labs. And after the death of the last member of the family, the okay, so that is called your so some property that whose owner is not there or owner is not found or there is no claimant on the property, then that will be converted into state property. And estate and labs also used simultaneously. Estate and labs. Okay, so that is called your estate and labs. You see these are two different things. Estate and labs in layman term, if the owner of the property dies, and has no legal heirs, then the property gets transferred to the state or the government. This is called estate. On the other hand, if the owner of the property mentioned as a person of beneficiary to this property, and if the beneficiary dies before the owner, then the property gets reversed back to the owner, to the deceased immediate successor. As and when the law describes. This is lapse. So in lapse, what happens? The owner of the property mentions a person as beneficiary to his property after his death. But if the beneficiary dies before the owner, then the property will lapse or will be reverted back, reversed back to the owner or to any nominee of the deceased immediate successor. This is called lapse. So you can see that various non-tax revenues are there. There are various non-tax revenues there. So likewise, non-tax revenues of strategy, irrigation, forest, fisheries, state public enterprise SPSU, and estate and labs. So these, kindly remember, these are the non-tax revenue in India by the states. In the states, there are irrigation, and your forest and fisheries state public sector units undertakings speech and labs. So I told you seat and labs. Okay. So these are the non-tax revenue of the tax and non-tax revenue of the center, and you can see that this distribution is partially tilt towards the center. The center has more viable source of income, as a more viable source of revenues and tax revenues. The states are given with some ordinary areas where it can impose taxes. Where it can get the non-tax revenue. So that is the major flaw in the financial devolutions. Okay. So these are the major tax divisions of the so you can see that the financial so it is clear that the state, the distribution of financial resources between the center and states partial or tilts to more towards the union. The union government is in a very comfortable financial position than comparatively than the states. Hence, states clamor for more financial autonomy and more things. But today that has not been done. We are a quasi-federal country, so some taxation powers and non-tax revenue sources are there, but they are not the viable source of income. Rather, they are very ordinary source of income. So states are devoid of their sufficient finances to meet their developmental objectives. Hence, this provision has been made, that is statutory grants or grant in aid. Statutory grants Now look at what is written. Granting aid statutory grants under the after Article 275 empowers the Parliament to make grants to the states which are in need of financial resources and not to every state. First thing. So apart from the devolution of tax and non-tax revenue, there are certain states, the states also suffer from financial scarcity. So with a view to meeting their financial needs, the center provides a statutory grants under Article 275 to different states who are in need of financial resources. Remember, this granting aid is not applicable to all states. It only belongs to some states, selected states, and different sums are allowed, and different sums are allowed, or different sums are fixed for different terms. And these are charged expenditure charged upon the Consolidated Fund of India. That means these are non-votable withdrawals. Another tax was there also, if I remember, discretionary grants. Discretionary grants were there. Article 282 enables the Union to make discretionary grants even beyond their respective legislative competences for any public purpose. Since the Constitution came into force, CSS rooted by Article 22 have proliferated, with many central sponsored schemes dominating subjects within states' legislative competence. Over the years, concerns have emerged over the use of Article 282 as a means of authorizing CSS, which inhibit states from exercising policy priorities over the subjects that are constitutionally within the legislative and executive domain. Through analyzing the use of centrally sponsored schemes in the area of public health as a starting point, a recent report by the BD Center of Legal Policy dives into the Article 282 and the development of the practice of intergovernmental transfers. The core of this research point is that fiscal federalism and centrally sponsored schemes, and I'm thinking about it, is a study of architecture of fiscal federalism in India through a constitutional and jurisprudential lens with the aim of developing reworked interpretation of that. Okay. So as I told you, different sums may be fixed for different states based on their specific needs. For instance, grants under Article 275 have been made to Tamil Nadu for promoting the welfare of scheduled tribes. Grants have also been made to Nagaland and Meghalaya for welfare of vulnerable groups. 275 is a statutory grants, and 282 under which the union or the states can make any grant for any public purpose, even if such purpose is one that lies beyond the respective legislative competence of the government. So Article 282 Kindly read it out. The transfer of जो statutory grants are made on the recommendation of the Finance Commission, but 280 discretionary grants are made outside the Commission's formal review. So Article 282 is being debated in the country recently because the center dominates or delves into the state subjects and grants that is also affecting the fiscal federalism, and mostly the 282 grants under 282 is made to finance the centralist person scheme designed or partially funded by the central government or implemented by the state government in accordance with the term fixed by the center. According to the budget 2021-2022, up to 23% of the total fiscal transfers to states are said to be through route of CSS, centrally sponsored schemes. Centrally sponsored schemes have been implemented by Article 282 of the Indian Constitution. Article 282 enables the Union as well as states to make discretionary grants even beyond their respective legislative competence for any public purpose. Means center can make discretionary grants for health purposes, or health is a state subject, and state can make discretionary grants for any union subject. That is the rationale. Since the Constitution came into force, CSS rooted via Article 282 have been proliferated, with many centrally sponsored schemes dominating subjects within states' legislative competence. Over the year, concerns have emerged over the use of Article 282 as a means of authorizing centrally sponsored schemes, which inhibit states from exercising policy priorities over the subjects that are constitutionally within the legislative and executive domain. Okay, for example, health is a state subject. So any schemes related to health by the center are funded by the states, funded by the center, centrally sponsored schemes. In this way, it inhibits the states from granting any things for the state subjects. So, report of the 15th Finance Commission notes that in 2018-19, the states had only 37.3% of the resources, but were responsible for 62.4% of expenditure that was incurred. To address this vertical fiscal imbalance, the Constitution's fiscal federal architecture allows multiple channels for the flow of funds from the center to the states. Predominantly, intergovernmental transfers are channeled through the following routes that we have already discussed: Article 270, 275 and 282. The use of Article 282 to implement centrally sponsored schemes emerged as a source of tension for the fiscal federal architecture soon after the Constitution came into force. Centrally sponsored schemes began to be conceptualized and implemented based on recommendation of the Planning Commission and National Development Council, both institutions established by resolutions. After the dissolution of these two institutions, CSS are made and effected by concerned ministries of the central government. For example, the nodal ministry for National Health and Mission for the National Health Mission is the Ministry of Health and Family Welfare. So, health being a state subject is pampered by or is executed by the center. CSS by nature are discretionary transfers made by the union to the states and routinely pertain to subjects within the state And concurrent list effectively via the instrument of centrally sponsored scheme, the central government can determine how and on what activities states are to spend their money. Resultantly, the autonomy which arises from the working of the list system is offset to an extent by the manner in which Article 282 is used. So there has been exactly one instance where the Supreme Court has ventured into the substantial question of the interpretation of Article 282. This was in Bhim Singh versus Union of India 2010, where the court was dealing with a challenge to the constitutionality of the members of parliament MPLADs. Constitutionality of MPLADs, a central sector scheme different from centrally sponsored scheme under Article 282. Central sector schemes are directly funded by and executed by the center. In this case, Supreme Court had the occasion to analyze the scheme of intergovernmental transfer created by 275-282. The Supreme Court held that Article 282 cannot be given a restrictive interpretation by the reference to the articles, as it is not subjective to any other provisions of the Constitution. Significantly, the court used the term quasi-federal to describe the nature of Indian Constitution. Based on this characterization and language of Article 282, the court held that both the union and states have the power to make grants for a purpose, irrespective of their legislative competences, provided by the purpose is public purpose. Within this meaning of the Constitution, given this judicial position, the use of Article 282 to effectuate CST is not per se unconstitutional. But it affects the federal relationship, as the state do not get adequate space to make policy initiatives or policy importance on the subjects mentioned in the state list that diminishes their power as a government. So it radically disturbs the federal fiscal balance 282, but it has not been done away with. It was earlier granted by the Planning Commission, now it is granted by respective ministries. Despite criticism, central sponsored schemes continue to exist. One of the abhorred aims of grants recommended by the Finance Commission under Article 275 is to address interstate disparities. The 15th Finance Commission has expressed concern over centrally sponsored schemes prevalent in healthcare and education, which have the effect of offsetting the advantage of Article 275 grants. In light of such concerns, the report analyzes the architecture of fiscal federalism in India and recommends a reworked interpretation of Article 282. While this is a wealth of literature on the working of CSS in the domain of public finance and economics, it has seldom been examined from a constitutional perspective. Okay, so these are the major things we have to remember, that Article 282 is a discretionary grants which is being not seen in a good light by the states. It imbalances, it is responsible for fiscal federal balance, and it is discretionary in nature because the government decides, and it is mostly through this article the central government uses centrally sponsored schemes in the states on the subjects which are in the domain of the state list. So that is very intriguing. Okay, so that we have seen that 282 empowers the central state to make any grant for the public purpose, even it is not within the respective legislative competence and is yet discretionary in nature. So as we have seen, we have discussed the major areas of financial relations starting from 268 to 282. 275 is a statutory grants made on the recommendation of the Finance Commission, and obviously they are charged upon the Consolidated Fund of India. Apart from statutory grants, this is also a grant. There is 282 under which the union or the state can make any grants for the public purpose, is one that lies beyond the respective legislative competence of the 7th schedule that mention disabilities of the union and states. So there are also certain grants that we have discussed under Article 268, under Article 269, under Article 269A, 270, 271, isn't it? So we have seen that the financial balance, fiscal financial balance is not properly nurtured by the present arrangement. More autonomy, more financial resources are in the pocket of the center. The states devour or clamor for more and more financial autonomy. We will see that various commissions have also focused on this sensitive issue of financial relations between the center and states. Okay, so this is all about your financial relationship between the center and states. Now we shall come to the major aspect of the tension area between the center and states. The tension area between the center and states, center-state relations, and we have discussed the financial relations, 270 financial relations related to center-state relations of glance. So there are taxes and taxes levied and collected by and returned by the states. There are 13 in number. We have 18 in number. 18 in number. Okay. There are taxes on land revenue, taxes on agricultural income, duties in respect of succession of agricultural land, estate duty. I have told you. So distribution of non-tax revenue we have discussed, and grants in aid, statutory grants, discretionary grants. Apart from that, there are also other grants. The Constitution also provides for a third type of grant in aid for the temporary period. Thus, provision was made for grants in lieu of the export duties on jute and jute products up to the states of Assam, Bihar, Odisha, West Bengal. These grants were to be given for a period of 10 years from the commencement of the Constitution. These sums were charged on the Consolidated Fund of India and were made to the state governments on the recommendation of the Finance Commissions. Then Goods and Service Tax Council also plays an effective role in the implementation in cooperation and coordination between the center and states with regards to the goods and services. GST Council of India is the premier body established under Article 279A. The council is a joint forum of the center and states. It requires make recommendation to the center and states on the following matters, means the taxes, cesses, surcharges levied by the center, the states and the local bodies that would get merged in GST. Goods and services tax, this may be subjected to GST and exempted from GST. Model GST laws and the threshold limit of turnover below which goods and services may be exempted from GST. The rates, including floor rates with bands of GST, etc. And Finance Commission has also some important responsibilities in this regard. It is appointed under Article 280 by the President. It makes provisions, recommendations to the distribution of net proceeds of taxes to be shared between the center and states. We have discussed it. Okay. So protection of states' interest. To protect the interest of the states in the financial matters, the Constitution lays the following bills can be introduced in the Parliament only on the recommendation of Parliament. one of the precedents, a bill which imposes various tax or duty in which states are interested, a bill which varies the meaning of expression of agricultural income ক্ষেত্রে as defined, a bill which affects the principle on which monies are may be distributable to states, a bill which imposes any surcharge on any specified tax or duty for the purpose of union. So the phrase net proceed means proceeds of tax and duty of the cost. The net proceeds of tax and duty of any area is to be ascertained and certified by the Comptroller Auditor General of India. His certificate is final. Then borrowings by the centre and states. The constitution makes the following provisions with regards to borrowing. The central government can borrow either within India or outside upon the security of the Consolidated Fund of India, or can give a guarantee, but both with the limits fixed by the Parliament. So far no such law has been enacted by the Parliament. Similarly, the state government can borrow within India, not abroad, upon the security of the Consolidated Fund of the state, and can give guarantees, but both within the limits fixed by the state legislatures. The central government can make loans to the states and give guarantee in respect of the loans raised by any state. Any sum required for the purpose of making such loans are to be charged on the Consolidated Fund. The state cannot raise any loan without the consent of the centre if there is still outstanding in any part of loan made to the states by the centre in respect with a guarantee has been given by the centre. So borrowings power of the centre are two-dimensional, centre and states. Centre can borrow not only within India but also outside India upon the security of the Consolidated Fund, or can give guarantee, but both within the limits fixed by the Parliament, but so far Parliament has not fixed any limit for that. State can borrow only within India and not abroad upon the security of the Consolidated Fund, and can give guarantee, but both within the limits fixed by the legislature of the state. State can make loans to any state or give guarantee in respect of loans raised by the state. So borrowings is like that. Another thing, the property of the centre is exempted from all taxes imposed by a state or any authority within the state, like municipalities, district boards, panchayats and so on. But the Parliament is empowered to remove this ban. The word property includes land, building, chattels, shares, debts, everything that has a money value, and every kind of property, movable or immovable, and tangible and intangible. Further, the property may be used for sovereigns like the armed forces or commercial purposes. So exemption of central property from taxations. The cooperation of the company is created. So the state government cannot impose taxes on the central property. Whether property here has a broader meanings. So it includes land, buildings, chattels, shares, debts, everything that has a money value, and every kind of property that is movable and immovable. So the property and income of the state is exempted from central taxation. Such income may be divided from sovereign functions or commercial functions. But the centre can tax the commercial operation of a state if Parliament so provides. However, Parliament can declare any particular trade or business as incidental to the ordinary functions of the government. Okay, notably, the property and income of the local authorities situated within a state are not exempted from central taxation. Similarly, the property or income of corporations, and companies owned by the state can be taxed by the centre. The Supreme Court, in its advisory opinion, held that the immunity granted to the state in respect of central taxation does not extend to the duties of customs or duties of excise. In other words, the centre can impose custom duty on goods imported or exported by a state, or any excise duty on goods produced or manufactured within the state. Okay. During effect of financial relationship or impact of emergency on financial relationship in normal times as discussed, but during national emergency as discussed above. So, first of all, during national emergency, while proclamation of center can modify so that is what under Article 252. When the proclamation of national emergency is in operation, the President can modify the constitutional distribution of revenue between the central and state, both tax and non-tax revenues. In this regard, the President can reduce or put off, or totally he can say no. He can reduce or cancel the transfer of finance, both tax sharing and granting aid from the center to the states during national emergency. The President can reduce or cancel the transfer of finance both tax revenue and granting aids during the during the national emergency, and this can continue for the whole financial year in which the emergency has ceased to exist. Likewise, in the state emergency, financial emergency also. During financial emergency, during the proclamation of 360 is in operation, the center can give direction to the states to observe specified canons of financial propriety and to reduce the salaries allowances of all classes of persons serving as the state and reserve all money bills and finance bills for the consideration of the president. To observe serving in the state. That is your implication of financial emergency. So financial emergency is imposed by the president when there is a financial crisis, or there is the financial crisis is out of control and the state is in financial poverty. Then the president can impose financial emergency under Article 360. And during this time, the fiscal federal balance is quite disturbed. It undergoes substantial changes, And the changes are like that the center can give direction to the states to observe the specified canons of financial propriety. The state will be directed by the center to follow some prescribed measures, prescribed canons, prescribed rules and regulations to maintain economy and expenditure, to bring or control the losses anywhere. Then it may also direct the states to reduce the salaries and allowances of all classes of persons, including the judges of High Court serving in the state, and to reserve all money bills and other financial bills for the consideration of the president. That means money bills and other finance bills cannot be signed by the governor. It should be sent to the governor for his considerations. So these are the steps taken by the government of India to contain the financial crisis of the country, and this happens when there is a financial emergency. Okay, these are the effect of emergency on financial relations between the center and states. And with regards to the president's constitutional emergency, the state administration is brought under control of the central government. So obviously this is not any financial balance is not affected, because it is the responsibility of the center to look after the state. There is no state government, so there is no concern arises. But during national emergency and state emergency, as we can see on the screen, that they get modified during the emergency, especially the national emergency and financial emergency. Apart from that, there are also certain tension areas in the states, and we shall discuss that. The tension areas. So we have seen broadly the legislative, administrative and financial relations. So why did the tension arise? Because till 1970s, beginning of 1970s, there was a single party domination in the country, and that is Congress party. So there was no such visible conflict between the center and states, because the one party domination of the Congress most state. In 1967's election, Congress party was defeated in 9 states and its position at the center became weak. This changed the political scenario, heralded a new era in center-state relations. The non-Congress governments in the states opposed the increasing centralization and intervention of the central government. This raised the issue of state autonomy and demanded more and more financial and other powers to the states. This caused tension between the center and tensions and conflicts between the center. So the center-state conflict, or you can say the tensions and conflicts, are largely due to the end of single-party domination era and advent of multiple party rule in different state, regional parties and others. So these are the tension. And the major focus area of the tension is there are different types of tension areas. So we can say that post 1967 development, when the single party domination era what is the tension area? Major tension area is mode of appointment of the governor, mode of appointment and dismissal of the governor, so governor being the constitutional head should have been chosen by the states, but he is appointed by the center and dismissed by the center. He holds office during the pleasure of the president. So he does more as an agent of the center than as a constitutional head, and that has been debated several times. And you have seen that the manner in which many governors have acted shows an unhealthy trend in the life of quasi-federal country like India. So mode of appointment is a major tension area, and many states have demanded for modification of these provisions. Then you have discriminatory or partisan roles of governors. That is also there. You have seen in recent times also, the governor in Tamil Nadu, governor in Kerala, governor in Maharashtra, in Arunachal Pradesh, in Rajasthan. They have shown some partisan role, partisan attitude, and which is very harmful, which is dangerous for the democracy, which is not sound, which is not good for the government of the Federation of India. So that is also a big tension area, and many states have demanded for change in this system. So number 3, imposition of presidential on partisan consideration. On partisan consideration, and that is also there. Number 4, deployment of central forces in the states to maintain law and order. Number 5, under Article 200, that is also a major tension area. improper use of okay. Okay. The management of all India services is also a tension area between the central and states. Many states have been gradually reducing the number of IAS, all India members of all India services in their states. That shows some sort of dissatisfaction among the states regarding this service. And then number 8. So these are the major tension area: mode of appointment, discretionary grants, discretionary partisan role, imposition of practices and rules arbitrarily, deployment of armed forces, reservation under Article 200, improper use of Article 282, management of all India services also there. And then use of okay. So we have noted about 11 areas where the tension arises. Mostly the center-state relation surround the financial crisis and also the delving of center into the domain of the states. So it has been a matter of consideration before almost all commissions appointed after 1960s. The issue of center-state relations have been under consideration since 1960s in this, and many commissions, including the first Administrative Reform Commission, have also considered the most sensitive issue faced by the Indian government. That is center-state relations. So we have seen that lot of areas where the center and state come at loggerheads, they are at loggerheads and they fight against each other, and there is a clamor for state autonomy heard in the corridors of India. So state autonomy is not over, the demand is still on, as there is a single party domination and most of the states are ruled by the single party. So the clamor for state autonomy is being somewhat deemed, but not that it is completely put off. So the issue needs special attention and special changes needs to be taken place in this regard. Otherwise, it will create unnecessary headaches, not only for the center but also for the state, and will jeopardize the quasi-federal structure in our country. So that is the things we have discussed, the major areas, major aspects of center-state relations and also the tension areas. So in the next class we shall be discussing the financial relations, the question and answers of this topic. We shall discuss center-state relations. Okay. Then we will provide emergency and scheduled areas. The next class Okay, thank you very much for being with me. Okay.